Just them now. Remember your nurses, them now. Remember your doctors, them now. My Highland don't sell out. No, 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 no. My Highland don't sell out. Please don't sell out. Remember your farmers, them now. Remember your workers, them now. Remember your neighbors, them now. My Highland don't sell out. Please don't sell out. My Highland don't sell out. Remember your people, them now. Remember the masses. I'm a soldier of His Majesty.
Good morning, welcome to Make We Talk here on Roots and 6.1 FM. Good morning, Owen, are you hearing me?
Yes, we're hearing you.
Yes. Good morning, welcome to Roots and 6.1 FM.
Good morning, welcome to Make We Talk here on Roots and 6.1.
Yeah, like your live is up.
Hold on a minute for me.
Good morning, Owen, are you hearing me?
Yes, we're hearing you.
Yes. Good morning, welcome
Welcome
to
to
Roots and 6.1 FM.
Owen, what is this? Why am I having a feedback, a recount to
Your
this?
live is up.
Hold on a minute.
My live from where, Owen? Owen, take a commercial break for me, please.
Why am I having a feedback,
Okay, sorry about that. Welcome back. Welcome to Roots 96.1 FM. Wherever watching and listening from around the world and the Eastern Caribbean, we do apologize for that little glitch that we have there. Now we're on. I have with me this morning. Before God and all mankind, I pledge the love and loyalty of my heart, the wisdom and courage of my mind, the strength and vigor of my body. I promise to stand up for justice, brotherhood, and peace. Good morning. Welcome to Make We Talk. Studio numbers are 876-2259-478 or WhatsApp call only 876-782-8235. My guest this morning is Miss Danielle Archer. Welcome, Miss Archer. Good morning to Make We Talk. Welcome to Make We Talk.
Good morning. Thanks for the invitation, and thank you so very much for considering me.
You are welcome. Before we go into the whole divulging of what happened yesterday, let me say good morning to all our families and all our friends who are watching, who are listening up to this, because everybody is glued to their radio and their YouTube. So you can go to YouTube, subscribe to the Make We Talk Jeffrey Tavares YouTube channel or the Roots FM YouTube channel. This morning we're going to speak about the murder trial of Donna-lee Donaldson. And without further ado, let I go into our guest here, Miss Danielle Archer. She's an attorney at law. Miss Archer, welcome
Good
again.
morning.
How do you put forward a bail application?
All right. Well, one thing I'd correct you on first. You said it's the murder trial. It's not yet a murder trial. It is at the stage of what we call in Jamaica a preliminary inquiry. It's where the information is presented and then the courts will decide how it is that it's going to be moved along. It's almost like a case management. So essentially, because he has been in custody prior to the hearing of the matter, At the bail hearing, the evidence would be presented to suggest whether or not he is a flight risk, which the Bail Act is asking for. And if it is satisfied that he's not a flight risk, he must satisfy that he's not going to be in a position to tamper with the evidence. That includes witnesses, and that he'll be available upon the date of the trial. Those are the essential ingredients to ensure that he obtains bail. There are others, we will perhaps call them primary elements, such as whether or not he is the sole breadwinner, whether or not he's had an impeccable record before the allegations, whether or not there are other health considerations that would invite the court to consider that he should not be in custody with the state. And those are some of the things that would be considered when a bail application is made. For the bail application to actually be successful or to get off the ground in particular, the prosecution must be open and serve the defense with all the evidence or the information they have pertaining to the matter, so that the defense and the court who is sitting can make a decision as to the validity of the information that they have and whether or not there is actually a case to go on to be tried at a subsequent date.
Okay. So yesterday, what happened in the court yesterday with the judge, the prosecution, and the defense? Where they had
Let me be very clear. You know, I am an attorney, and so I speak only from the knowledge that I have.
Okay.
I was not present in court. I can only
I know you wasn't present. I know you wasn't present.
By the media.
Okay.
Right. So let me just be clear. From the media reports, it is quite clear that what transpired yesterday was that the prosecution indicated going to be withholding certain witness statements on the basis that they thought that there was going to be or that there is a threat to the safety of the witnesses. Certainly, the court was in a difficult position because they would want to ensure that there's a balance and to respect that which the prosecution says, but they were constrained by the recognition that other statements were shared with the defense that revealed the identity of the very witnesses that they're trying to uphold, the safety of these witnesses that they're trying to uphold. At the same time, the court was saying, but how is it that you're saying their lives are threatened when you have willingly provided their names without redacting them? It is the custom in our courts that if there is in fact fear that there's going to be some harm that would come to a witness, that you would redact. To redact means to take out the name of the witness, to take out the address, and to take out any identifying characteristics of that witness and to serve the statement in any event. What happened yesterday was that they had already identified who these witnesses were, so the defense knew who they were talking about. So to ask the court to not serve them with these witnesses was novel, to use the words of the court that has been reported, that it was a novel situation because you already told the defense who these witnesses were. You gave them their names. So to withhold that information was an unusual course because in court, at every stage of the matter, whether it's almost finished or it just start, disclosure is continuing. And you have a duty to share all the information you have with the other side. So yesterday transpired was a failure on the part of the defense to share the information that they have, and they seem to have sought to do so to withhold this information on the basis that there is a threat to the safety of the witnesses, albeit they had of their own choice shared the names of these witnesses with the defense before it appears.
As an attorney, can you tell the wider Jamaica, and maybe, you know, I know you're not speaking on behalf of anyone, speaking on behalf of you being an attorney, but the circumstances in which bail may be denied?
Well, I think I started that out before, but to be more clear, bail is usually denied if the person is a flight risk, that they will never turn up for a trial. Bail will be certainly denied if it can be shown that the person is going to intimidate a witness or to tamper with evidence. So let's say, for instance, you for sure know that he's going to be using his authority or his position to influence the witnesses or to damage a crime scene or to change the circumstances that are going to be relied upon to prove the case, then bail will certainly be would be denied. bail would also be denied if it is that it can be shown that he is, when I think I mentioned that he would not be cooperating with the police. He won't be giving information that he has shown that he's perhaps a threat to the witnesses personally or even a threat to himself.
Mhm. Okay.
Those are some of the conditions under which bail will be denied. Always remember, when you think about bail, there are two elements to granting bail. The first element is to ensure that the person is going to turn up for trial. So the courts always say, well, we're going to keep you in custody because we know so you're not going to come to court. You're going to run away. You're going to be hard to find for court. And bail will be denied if it can be shown that you are going to threaten witnesses, contaminate evidence, or be in a position to influence the outcome of a matter, which is why yesterday you'd have heard that one of the witnesses, there is an allegation that he has not turned up for work because of certain threats he has received.
Okay. I think my producer Owen Brown has a question for you. Mr. Brown?
Yes, good
Owen?
morning, Archer. Yes, good morning. I actually wanted to know because you mentioned something about information
Not hearing you, Owen.
witnesses that were
Owen?
there
Miss
with
Archer not hearing you.
identifying information. What would be the implication then of that, and why is it that it was not redacted?
Owen? Are you hearing us, Owen? I don't think Miss Archer heard you, you know.
Wow.
Can you repeat the question for me, please?
Okay, sure. Are you hearing me now? Is she hearing me now?
Don't know what's
I'm
going
not
on.
sure she's hearing me at all. Hello?
Miss Archer, are you hearing us?
I'm hearing you, but I'm not hearing him.
Oh my.
She's not hearing you at all, Owen.
All right.
What's the question you're asking, Owen?
Right, just referring to her because the information, as she said, was for the witnesses, identifying information was given. Why was that information not, as she said, redacted?
Okay, he's saying why was the information pertaining to the witness was not redacted?
Well, I don't want to go into the mind of the prosecution. Perhaps it is that they neglected to do so at the time because they didn't think it was a threat. That's one. It could have been negligence or an error on their part, failing to ensure that the statements that they handed over did not include that particular information. It could also mean that it is a ploy, unfortunately, being used by the prosecution to get more time to put things together. So rather than disclosing it, they came up with an explanation to try and withhold information, which I hope would not be the situation, but it is something that has been said by other persons to say, but why would you do this? Is it that you're asking for more time, but you don't want to ask for more time, so you're trying to play some kind of game because you willingly handed over this information? As well as I said, it can genuinely be a situation where they have not yet disclosed the names of those persons who they have. Those four, well, one report says it's 6, another report says it's 10 statements that are outstanding. We don't know for sure how many statements are outstanding. So it could very well be that it's not the statements that have been shared that is cause for concern, but the statements that they have in their possession, or information in those statements that they have in their possession that they don't wish to share at this time.
Okay.
Those are just some of the reasons I can conjure to explain their posture yesterday.
Yes. Firstly, before we go any further, I must apologize to my viewers. My camera system went haywire a while ago. I do apologize for that. Mr. Brown, do you have any more questions for Miss Archer? Let I go ahead with another question to her?
Oh, you can go ahead.
Okay. If there was no bail application or bail hearing, because of what is being said at the court yesterday, if I'm hearing clearly, that there was no bail hearing or application put towards the court, how is it that the attorney yesterday was asking for bail?
No. The attorney would come prepared to ask for bail. That's your first duty as counsel.
Right.
My client is in custody. When the matter comes up for court on the very first hearing, my intention is to get my client out of the prison, out of jail, until it is that we can come before the court and hear what the allegations are and to answer to them. So bail, remember, bail is not something, and I think it's something that we need to be very clear on. The purpose of bail is to ensure that you can have a trial in a fair manner with the accused present and with the witnesses and the evidence intact. So you will come to court to be prepared to ask for bail for your client. Not being able to ask for bail, and usually it's the first recourse of a criminal lawyer. The first time the matter comes up to court, your first position is he in jail, is he in custody or not? If he's not in custody, there's no need for bail application. The next hearing date is going to be to have the preliminary inquiry so that you can find out what the nature of the charges are. If he's actually in custody, you're going to be asking for bail. And so the lawyer is right. She comes and says, I'm here to make my bail application. This is the information I have, but she would be stopped from making that application because she doesn't have all the evidence. She doesn't know what the evidence is that they're holding. What if the evidence says that he is a flight risk, that they saw that he was taking a passport somewhere or he made arrangements to go somewhere? Then that would certainly affect her bail application, because then the prosecution would have information that she doesn't have. So she's coming to court for a bail application, but she would not be in a position to make a bail application because she doesn't have all the information before her. There was nothing wrong with her coming to make the bail application. It is well within the right of any good lawyer to seek to have your client come out of custody upon the very first hearing you have before a court.
Like I have you here, Miss Archer. Someone called me this morning early and was saying to me that they don't understand the Bail Act. Is there any way you could explain the Bail Act to us, who can be granted, and what Justice of the Peace can do that, and the station can give you station bail?
Right, but there are different categories.
Right.
So it would take some time to be able to go through the Bail Act, but I do believe at the beginning I did share with you some of the considerations for giving bail. Those considerations would be the same considerations that would certainly apply when we are considering whether or not somebody is to be given bail. You can be given station bail, as you have mentioned, for minor acts. And when it comes to the more serious acts, such as murder, aggravation, robbery with aggravation, possession of firearms, those are more serious offenses, which would certainly go before the court. And the court would always want to ensure that the person is going to turn up for court and the person is not going to interfere with the witness or tamper with the evidence. Those are the considerations. Bail is not something that is thrown upon you. Let me flip it another way. Bail, sometimes we say bail is as a right. So you have a right to ask for bail. There is no blanket law that says once you have been charged, you are to stay in custody until your matter is heard. You can only stay in custody if it is that they are concerned about your flight risk. Also, they may also be concerned about the fact that you are involved in other matters, that they're investigating a matter that concerns you. And if it is that you are not in custody, you're going to interfere with that investigation. That is also a consideration. And that may very well be a consideration in this current case, given the tentacles of the accused. An accused who is a police officer who has been noted to be connected to certain and several different persons, and they want to be able to say that he may have the ability to influence certain people. They may want to argue that he's not a fit and proper person for bail because not only is he a flight risk, but he poses a threat to witnesses, he poses a threat to being able to tamper with evidence. And certainly, if they are investigating connected matters with him, they would perhaps want to argue that they will not be able to properly investigate these connected matters when he's out on bail.
I wasn't hearing her clearly on the latter part because it sounded a bit.
Does that assist?
With the connection, sir, Jeffrey.
Hello.
Yeah, Miss Archer, you got a little bit of muffled early on the last statement you were making. Could you repeat it for us, please?
I was suggesting that if we apply the Bail Act to the current situation, one of the other concerns that the court would contemplate is whether or not they are related investigations to the current matter, to the main matter, that they are concerned that the accused would interfere with. We don't know with that for sure, but that is also a contemplation when giving bail. Whether or not the accused is connected to other matters and would affect the investigation into those matters.
But Ms. Archer, some may argue that the new bail act that is coming in now, it may infringe on the rights of the Jamaican people.
I can't speak to that. I haven't seen the proposed act. The only thing that has been said and was said by the minister with responsibility for the new bail act or the proposed bail act was that there was going to be this change to the situation. In the absence of being able to see the new act, I'm unable to adequately comment. Comment on it at all. But I will say that the current act does provide for bail in circumstances. It does allow that the courts have a discretion, and the courts have often used it to deny bail to persons who they feel are connected to an offense or are repeat offenders. And the court has done so utilizing their very own discretion to ensure that the person who they deem to not be in a position to go on bail has remained in custody. They have done so on the premise that they are satisfied that they are a danger to society. The current bail act does facilitate that. So if it is proposed that you're going to now say for Stephen Aki, you are going to be held in custody until the matter comes up, it is going to be arguable that it is a breach of your rights, because you do want to look at whether or not it is reasonable and fair in all the circumstances.
You know, because at one point when I heard that from the person responsible for the bail act, the constitutional minister, I was saying to myself, then if I drive my BMW, my convertible BMW down in halfway tree and park it, and come out of it, and somebody drop a gun inside there, I don't think the gun was inside there, is that they're going to lock me up until,
there are persons who will argue that perhaps because you are who you are, you're able to explain that and stay on bail. That may very well change for somebody from a different address and a different lifestyle, even if they were driving that convertible, because it is presumed that because they are from a particular area, they are not entitled to bail. And that is a sentiment coming from the society, because oftentimes we look at the issue of bail and we look at the issue of the enforcement of penalties based on who we are. And we get offended when we say, oh, there's a difference in the society based on how the laws are applied. So that is my view from the outside when I hear persons talk about who should get bail and who shouldn't get bail. And I often say to individuals, the best way to assess the issues is to ask yourself, if it was your son or your daughter who was found in the same position that you have just created, what would you want? Would you want them to have the book thrown at them and for them to stay in custody for the 4 or 5 years until the matter is tried? Or would you want them to go out on bail? Just saying.
But some may also argue, Miss Archer, that there's not a body being found. So how is it that they can go ahead and charge the individual for murder?
Well, you're reverting to the current situation. One would have to look at the forensic evidence that is available. The information coming from the numerous media reports suggest that forensic evidence is available. One would have to wait to see what that evidence is to be able to determine the value of that evidence. Certainly, the prosecution would be satisfied that they are able to prove beyond reasonable doubt that this evidence connects to the missing person, and they have sufficient evidence to conclude that this person has died. The culmination of circumstantial evidence plus the value of the forensic evidence may very well be sufficient for them to have the court come to a conclusion that even in the absence of the body itself, there is sufficient to determine that the person has died or that the person has caused the death of another.
The lawyer of the accused was saying also, Miss Archer, that, it took the police 3 times to go to the gentleman's dwelling to find some blood stain. One may argue that in court also.
Certainly, and that would be open for the defense. One of the things I look at when we have this conversation about Donna-lee, and I'm very grateful for the opportunity that it has been placed on the table. It is my view only, that the level of investigations that we have here on the island requires a lot more.
I believe that it is natural to expect that the best evidence can be found within 24 hours of the incident being committed. And I say 24 because that is when certain things are fresh.
Yes.
It is possible that we can raise a concern that if you had to go back 3 times on 3 different days and 3 different occasions, what and what could have been done. And so one can argue that the investigation is not as sufficient as it should be. You must also remember that unfortunately in Jamaica, our officers don't close, when our officers close a case, it is not to say that the evidence has been completely found and is now before the court. When
Miss
a man
Archer,
is charged,
Miss Archer, hold a minute for me, please. Hold your thoughts for me, please. We're going to take a quick commercial break here and make we talk on Roots 96.1 FM. Wherever listening and watching from around the world and the Eastern Caribbean, it's 11:30 in Kingston, Jamaica, 12:30 in Fort Lauderdale, Florida. We'll be right back.
My island don't salute.
Hi, I'm Sharon.
Hi, I'm Marcia.
I'm Adrian.
Join us this and every Wednesday morning for Extraordinary Abilities on Roots 96.1 FM. Join us for news, views, and interviews with extraordinary people. Extraordinary Abilities every Wednesday morning, 9 a.m. to 10 a.m. on your extraordinary radio station, Roots 96.1 FM. It's gonna be fun, informative, and educational, but most of all, it will be extraordinary.
At MOJ Ministry of Justice, come access quality service to keep order within the nation. We put together good legislation, legal aid to your pocket. A little is child diversion for you to need expertise. Victim service will help you cope with grief. Restorative justice, build back the peace. No matter where you come from, how we say justice for all Jamaicans. MOJ Ministry of Justice, come access quality service.
MOJ, taking justice to the people of Jamaica.
Become the hero on the scene by taking the COVID vaccine. Get vaccinated as soon as you get all the facts. Don't listen to the rumors. This vaccine might just make it possible for teachers to sit face to face with schoolers. This vaccine make it safer for everybody, from the young to the elderly. Don't you want to go back to living normally when things were more orderly? And if you wanna live a long good life, then we all have to do what's right. So let's get vaccinated along with the heroes on the front line.
A message from the Ministry of Health and Wellness.
Salute.
Welcome back to Make We Talk here on Roots 96.1 FM. My island don't sell out. We do not own the copyrights to this song, Burning Spear. We're talking to well-renowned counsel, lawyer, a lady who speaks her mind, you know, when she was on the radio station. And I used to love to listen to her. I mean, maybe I should ask her to, you know, do a program with me to speak her mind. Because listen to me, when she does that, a lot of Jamaicans sit and listen, and they take clips of the audio and, you know, they post it on various social media. And believe you me, Danielle Archer is a person who I think you can sit down and you can rap with. She can, you know, she'll explain things to you. And I must say, you know, it's my pleasure to have her on my program this morning. Miss Archer, welcome back.
Thank you so much. The flattery will get you everywhere, they say. So I'm rather grateful. I will say I took the opportunity during the break to just pull up the Bail Act because I wanted us to be clear on what the Bail Act is, so that we can be sure and satisfied that there are certain requirements that the judge has to look at.
Hold on for me, Miss Archer, hold a while for me, please. The studio is saying to me that they're having a little bit of problem hearing you. So I don't know if you could speak a little bit closer.
Are you hearing me better now?
Yes, a little bit better now. Yes, go ahead.
All right. So I wanted us to share a little bit with you on the Bail Act because I want you to be satisfied that the current Bail Act gives certain authorities to the court, to the justice of the peace, or the police officer who is contemplating bail. A little review of the Bail Act, you will see about 6, I think, considerations. So they're going to look at the nature and the seriousness of the crime. They're going to look at the character of the defendant, his antecedents, meaning what's his history? Has he been involved in crime, connected to crime before? Who is he associated with? What is his community's ties? What are her connections? They're certainly going to be looking at the defendant's record with respect to his fulfillment of bail. If he was charged in another matter before, did he comply with the bail requirements? Except in the case of a defendant whose case is adjourned for inquiries or a report, the strength of the evidence of him having committed the offense or having failed to surrender to custody. So the court is going to look at that. And that is why those statements are important, because they want to see the strength of the evidence. They also want to consider whether the defendant is a repeat offender. That is to say, a person who has been convicted on 3 previous occasions for offenses which are punishable with imprisonment, or they can also look at the factors which appear to be relevant, including the health profile of the defendant. And I had mentioned that to you before.
Yes.
So the act actually states those areas, and the judge, the police, or the JP actually looks at those areas to determine whether or not the person is to be granted bail. It goes on further to indicate that the person could only be kept in custody for his own protection, or where he's a child or a young person for his own welfare. So currently, the Bail Act sets out those parameters which any judge can use to determine whether or not to grant bail or not.
So, based on this case that is in front of us now, in front of the entire Jamaica, do you think that well, let me not say that. Let me not put you
perhaps
on the spot.
before you put that question to me, let me close that which I was saying prior to my clarification on bail. I had raised with you my concern about the quality of our investigations. Every Jamaican is concerned about the crime rate. Every Jamaican puts the police from time immemorial to say that they're not doing enough. I have joined that argument and I have been specific. I do not believe that our investigations are sufficient to determine and to assure convictions. When our police officers place matters before the court, you can test that which I say. For the next 10 or 12 matters that you have in the future, you can listen out for it, or you can go back to the most famous matters. On every occasion, you will find that the matter goes before the court. The police say the file is not yet complete. There are still investigations ongoing, particularly in high-profile matters. And as a result of that, this is my view, there's nobody else's view, that in the absence of the complete file, you cannot be sure that the investigation is complete and that the evidence that is required is sufficient to bring forth a conviction. There is much argument about the need to have witnesses come forward and talk. My position is, man no have to open their mouth to tell you what go on with the murder scene. But we can look at spent shells, we can look at the positioning, we can do the we can do the testing of utilize the drones, we can utilize the evidence available to us to see who was where, what, when, and why, so that people are confident that our investigation skills are adequate to confirm that a man was there even when him say him not there, if you follow my line of thought. So I am of the view that we need to make a switch in how we think about convictions. Convictions cannot come about just because we present a man to court and say that we have charged him. Many times we charge a man and the file don't complete. We should be in a position to charge a man and take him to court, knowing fully well that we have the evidence that is required for the conviction. And when we close the file in Jamaica, ask the police, as far as I'm aware, that is the situation, that they look at the fact that somebody has been arrested. It is not an issue that they have secured a conviction, but it is rather that a person has been arrested for the crime. And so you can look at their numbers and say, whoa, golly, they're doing adequately well because they have this number of arrests being made. And this is how you close cases. To my mind, we need to shift our outlook and close cases when there are convictions in the matter.
But Ms. Archer, some may argue that the JSF came under public pressure. That is why they end up charging the gentleman without, well, I shouldn't say any evidence, without, substantial investigation.
Well, that is normally the case in many of our matters, that there is not an adequate response to the investigation. And so to pacify the public, we send people out and we charge them. And if you follow the matter 5 to 6 years on, the matter turns out that there was not sufficient evidence to convict him and the matter is thrown out.
Ms. Archer.
So what we're looking at is we're looking at a lack of accountability of the heads of the police force. We're looking at accountability in terms of talking about the quality of investigations.
We are celebrating 60 years of independence in this country. And our justice system in Jamaica is not for the common people who live below Crossroad. Nobody who listens to my program always say, Jeffrey, you must stop it. But I'm not going to stop it. The people of the Vumvava and the Vumvavi will always get away with things in this country. But the people below Crossroad will be sentenced to how many years in prison? Is it that, and I am speaking on the behalf of myself, not of Roots FM, nor the Make We Talk program. This is Jeffrey Tavares speaking now. That the case that is before the people of this country, a lot of people is having doubt about it, Miss Archer. That the case will just sweep on the carpet.
Jeffrey, one of the things as an attorney who has had the benefit of doing work I've done a lot of legal aid matters. I started my practice focusing on a lot of legal aid matters, recognizing that justice was costly to a lot of persons. So I accept your point that to many persons, access to an attorney and access to the use of the facilities of justice can be expensive. And there's also that position that says that persons below a particular address get a higher sentencing and reckoning than persons above it. And it does reflect that to my mind in this situation, because it does appear, that there was pressure that was brought to bear upon the police. But here's a twist, and it's something for us to consider. Was the twist not just because of an address, but because of who the accused was? So when you make such statements, let's be mindful that we do operate, and I have been on record to say that our society is classist.
It is.
And our society is created on classism, and classism perpetuates how we look at corruption. If the white man and the brown man transfer money to each other to buy stocks or to bring down a company, we're not going to focus on that. We're not going to say that's a corruption, that's a two-man do business. But if Black people do the same thing, or the poor people do the same thing, it becomes an issue. You see the point I'm making?
Yes.
To my mind, that is how we operate. It's okay if you're brown. Brown people, they say get away with more because they are in a particular class. If it is that you're not brown and you're Black and you come from a particular address and you're here nappy, then you have a different answer to give than a person. We have to deal with those issues. Those issues will always cloud how we perceive justice and how we perceive corruption. And how we perceive justice and how we perceive corruption will certainly influence how we see incidents like this. And in this particular instance, it's not just an issue of classism, but it's also who it was. In other words, you're a member of the police force. Just like it is when we have issues involving politicians, there are no exceptions to how investigations are done, because guess what? The police and politicians are considered to be connected. So the rules may be different for them because our society expects that their rules will be very different because of who they are. And it is in that conundrum that you drop your question that you asked me to say, that is what people are saying. And I can't say that's not what they're saying. The most I can say to them, though, is that having worked within the justice system, I hold no brief for the judges. But I do find that if there is adequate evidence, once there is adequate and sufficient evidence, you can be assured that there is going to be a conviction. If the matter is to be tried, the onus is upon those who are jury members to turn up, be present, and utilize that vehicle of being a part of the jury to make the convictions.
But Ms. Archer, sorry to be cutting you in the middle of your statement. A lot of Jamaicans are saying, you know, why should I be a jury when, number one, they don't pay us good, and number two, how secure are we?
So let me ask you that now, Jeffrey. You see how we like to talk about money?
Yes.
My problem is that there's some things that come with being a part of our civil duty. So if we're always going to sit down and say, government now pay me enough for turn juror, you don't complain when there's no conviction. You take on a crime and take on yourself and say, like, who can buy burglar bar? Burglar bar it. Who can pay for security? Pay for security. But there are basic things, and I'm very passionate about this. There are basic things that we need to do as part of our civic duty. Make we go on a court as a juror and decide, say, we are going to change out the whole system. You don't think on a gunman are going to get where cause we not have God adjourn today? We are turn up as members of the community. What we need to do is put ourselves there in the justice system and say, judge, government, we not pay we a small money for lunch money. We now come here for that. We are come here because we are part of the solution to this problem. So when jurors start coming out and the court start having overflow of jurors and they have no reason to adjourn no matter, or they have enough jury to hear matters, and our gunmen or criminals understand that they are people willing to come out. Some of us have to step out there, Jeffrey, and stop saying, oh, we're afraid. Not for we know who the gunman them be.
True.
Right? But so there comes a point here. No, sorry, Jeffrey. Some of us, let me finish.
Right.
When it comes to saying that we are fearful, we have never had that situation in Jamaica where you have jurors coming out telling us that we now go on no panel because man threatened me. And if they do, we have resources for that. We have jurors who make it a lifetime. I'm from the parish of Manchester, and there are many times I turn up to court and I can recognize a juror because I got them do. Then I have no problem I turn up as juror. I do them job that. And if we start to take that responsibility and say no to fear to turn up for jury duty and yes to our civic duty, this is our responsibility, not just for voting, but for those who want to participate in the system. They turn up and let the criminals know that the public is taking a stance and we are providing our service by being jurors. I guarantee you, you can come back to me on it, but I guarantee you, there will be an uptick in the strength of convictions and the uptick in how many matters are dealt with because there will be less adjournments and better evidence, fresh evidence, because the state of the evidence, many times witnesses, because matters get adjourned for years and years and years, the memory fade. And when the memory fade, the evidence disappears. That's my 2 cents. So when we talk about this, I am thinking that it is our opportunity to take it as a call to action, that we ask and ensure that the JCF and those with the authority properly investigate, and they do the investigations as early as possible so that it can be fair. And when it is done early, it is not just a question of charging people just because public call you and say you have to charge a man, but you have the adequate evidence to do so that you don't fear going before a judge and showing the judge the information that you have, because you know for sure that the information is adequate to survive a bail application and adequate enough to survive a trial in the matter.
The voice of well-known attorney.
This morning, Jeffrey, the good morning.
You know, I must have you back on this program, Miss Arch. I hope it won't be a stranger to come back. I would love to have you and my good friend Wilfred Rattigan on.
Oh Lord, you're gonna make people start stoning me. Either that time I have to go run away and run after. But as I stand, I speak always with the conviction, knowing that I speak always wanting to do better for Jamaica.
Yes.
I tried my very best not to just tear down, but we have to get to that point now where we stop talking and start putting solutions on the table. And I do find that your program, and oftentimes by Mr. Rattigan's approach, he always speaks from a point of knowledge that when you share this information, you empower people to do more and to do better. So it would certainly be a pleasure for me to reappear upon your program, and we can certainly speak about whether or not we can do a program together. I would be interested to hear how we could do that.
Appreciate it. And I must, I hope my producer, Owen Brown, is listening, you know.
I am listening, of course.
You know, the voice of attorney at law who is on my program, Danielle Archer, giving us the whole legal conversation of, you know, what happened yesterday and other instance of, you know, encouraging people to go out there, be jurors. If we be jurors, then the case will not be put off. That's what she said. So I encourage everyone, if you're called upon to be a juror in any case, go ahead and do it. I know you're saying that, you know, why is it that we can't convince politicians to what they're doing to us in this country? But until we come together and start the chat according to the former, well, the present Secretary General of the Commonwealth, she don't chat. If we start the chat and action, as what Miss Archer said, then I think Jamaica could be a better place for the next 60 years for children. Danielle Archer, attorney at law, thank you very much for coming on to Make We Talk.
Pleasure. Have a good one. Blessings.
Same to you. Thanks much. You know, Owen, we sit here in this country, you know, and we're trying to figure out the case between Noel Maitland and Donna-lee Donaldson. And based on the level of knowledge that I have, I'm not going to say anything about the case. I would never say that. But a lot of Jamaicans are saying to themselves, are they going to get justice? You know, I wish Dudley was in studio. Owen?
I'm here.
You know, I wish Dudley was in studio to explain to us.
He had some technical issues. He wanted to come, but he had some technical with his system.
Okay. Put on your camera, Owen. Let us talk for the few minutes we have on the thing here. I know you may be busy, but you know, if we as Jamaicans, you know, could just come together and approach things from a different angle. Yes, our justice system in our country is out of whack. I agree that our justice system need overhauling. For 60 years, we have the same justice system. We have some laws in the book from the 18th centuries. And a prime example, the same Minister of Justice, Delroy Truck, when a notorious criminal went to Barbados on a fake passport and came back into Jamaica. On the fake passport, when he was charged $100 Jamaican dollars. And the Minister of Injustice, Delroy Truck, came on national radio and TV and said that they were going to the drawing board to pass legislation until this blessed day none pass. So people must understand that the Jamaican people don't have any faith in our justice system in this country. We don't have any faith in our justice system. And the time has come that we're talking about 2030 Jamaica. The time has come wherever Jamaicans from all walks of life must come together and call for constitutional reform to amend our justice system in this country. The laws in this country need to be amended. You can't just go in a parliament and pass law to suit you and your favorite few. The laws in this country must be amended to suit the poorer class of Jamaicans from below Crossroad. And only the people of the Vumvava and the Vumvavi. You know? We live in a look at it. I switched from the whole Donna-lee thing because I have a few minutes leave to talk about our teachers leaving the education institution. And you know why they leave the education institution? Because successful government have a successful government. Treat them as if they are nothing. You can spend $40 million of taxpayers' money to campaign to become Secretary General for the Commonwealth. And is that profit in Jamaica? $300 or $200 million on Grand Gala when our teachers are underpaid in this country. Our nurses, our doctors are underpaid in this country. Our farmers can't even sell anything because of imported food. We want foreign food for yam. I'm talking about a 2030 vision in this country. Huh? When the corruption stinks like Riverton Dump. It is a damn shame. From 1935 until now, we're celebrating 60 years. From 62 until now. And our teachers in this country and our nurses and our doctors are underpaid in this country. While politician pocket is fat like fat turkey. It look like them forget that it's the teachers who teach them to have all kind of science and arts and all kind of sit behind their name. Bachelor of this and Bachelor of that. Bachelor of Jeffrey, behave yourself this morning. Behave yourself this morning, Jeffrey Tavares. Because I have a talk this morning and run me off of Roots FM. The time has come, Jamaicans, to call a spade a spade. And I hope and pray that justice is being done for Donna-lee Donaldson. I will not stop speak out. I will not stop asking questions where to be asked. Because Donna-lee Donaldson deserves justice. Her mother deserves justice. Countless of women in this country were brutally murdered by insane men. I must have Dr. Mark Lockhart on the program one of these days to talk about mental psychology because some of we gone mad. We believe that when we invest in a woman, we own them. We don't want nobody. This is where I say so long from here. I must apologize again for the camera. That, you know, I do apologize for that. It wasn't intentional at all. I apologize for that. But I say to my fellow Jamaicans this morning, stand up for justice, brotherhood, and peace.
Yes.
Stand up for justice. This is Jeffrey Tavares saying thank you for listening. Thank you for watching. Remember to like, share, and subscribe to the Make We Talk Jeffrey Tavares YouTube channel and the Roots FM YouTube channel. Until you hear my voice again, I'm Jeffrey Tavares saying so long. May God bless you. And may God bless Jamaica land we love. Good afternoon.
My Highland don't salute. My Highland don't salute. Please don't salute. My Highland don't salute.
That was Make We Talk here on Roots FM 96.1. Yeah, man, wonderful program.
Teach us them now.
Different angles. It's now 12 o'clock here on Roots FM 96.1. We will be going to a quick commercial break, and after the commercial break, we have our Must Bus song coming up. All right, so stick and stay for that. As a matter of fact, let us head into our Must Bus package, and then we head to the commercials after. All right. So the must bus this afternoon is Minister Treasure with the song Jehovah.
My God, you know. He's ready.
As I wake up that morning, first thing I got me call. Now my life can't be stand tall. Look to the hills where the help come from, cause the blessing it have no overall. Hey, Father God, that you will get the praise. That's why me calling every night and day. But me nice, receive the mercy and grace. We're calling your name, Jehovah Jireh.